Ms. Cutts.
Thank you, Your Honor. We are today in State of Ohio versus Yazan Albana, case number 25-CR-000-094. Defendant is present in open court today with his counsel, Timothy Deeb and Jay Schlackett. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on June 26 of 2025, where he pled guilty to count 3, menacing by stalking, a felony of the 4th degree, count 4, attempted disrupting public services, a felony of the 5th degree, and the lesser included offense of count 5, domestic violence, a misdemeanor of the 1st degree. At that time, a pre-sentence report and victim impact statement were ordered. It's the state's understanding that those were completed and have been provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you. Mr. Schlackett, any reason not to go forward with sentencing?
No, Your Honor.
Anything you would like to say on behalf of your client at this time?
Judge, before Mr. Deeb and I prepare any remarks regarding some mitigatory comments for this young man, would you please accept a statement from his cousin Sam Salah, S-A-L-A-H.
Sure. Mr. Salah, you can just stand right there, state your full name. You just spelled it, so I appreciate that. But keep your voice up so that we can all hear you, and it's being recorded, so make sure you do that.
Hello, Your Honor. My name is Sam Saleh. I am Yazan's older cousin, and Yazan has been like a little brother to me since we grew up together. And he's a very good man, very full of life. He's very positive, very harmless. I know the tempers flared that day, and we all want to make this right. I believe he did learn his lesson. I talk to him every day while he's in there, and he's very sorrow and very, remorseful for what he's done. And you would please, if Your Honor, if you could please release him today, we would all be very helpful. Anything else beyond that, we'll house arrest, whatever you'd like to do. But please, if Your Honor, we will make sure that this kid will be on the right path after this. And I know himself is very sorry for this whole mess and everything that's happened. And he couldn't wait for his son to come out and for all this to happen. It's a very sad situation, and we're all here to support him. We love him. Nobody's here for show. Everybody's here because we love him, and we want to make sure, hopefully everything, you can make your decision on all of the support and help that he will get if he comes out. Thank you, Your Honor.
Thank you. Mr. Schlackett?
Thank you, Your Honor. May it please the court, on behalf of Mr. Albana, Mr. Deeb and I did take the opportunity to present a sentencing memorandum. We truly would like to thank you, Your Honor. I know the court's very busy, and you took the time to read everything, including our sentencing memorandum. I know that I had reflected in there that he had no prior record. I just overlooked the fact that he had these misdemeanor marijuana case several years ago, and a paraphernalia, which was probably a pipe or rolling papers. As you know, Your Honor, he's 25 years old. He's here with all his family. His father is the owner of a place called Prince Tire. I don't know if you've ever driven by it in Willoughby. But Yazan really completely operates it on his own. I mean, it's his business, although he's not the legal owner. The business is certainly having some problems with him not being there, but these are all collateral consequences of decision-making in our lives, and he got nobody to blame but himself, and he's certainly not blaming you. As you know, Your Honor, he was remanded for violating the terms and conditions of his bond because he tested positive for marijuana. He's been now with jail time credit from the couple of days before and the days since remanding. He's got 29 days in on this F4, the F5, and the misdemeanor. Judge, I looked at all the sentencing factors and kind of highlighted them under 29, 11, 12, and 13. I think that you could possibly say, well, the relationship facilitated the offense, but that's kind of part and parcel of every domestic violence and things of a relationship issue.
Well, the domestic violence is the misdemeanor here. The other ones
Yes.
are felonies.
It is a misdemeanor. The other felony, Your Honor, is taking a phone where they were arguing over a phone, and then of course it's a pattern of where they'd had some disagreements.
It's the stalking case.
Pardon me?
That's the stalking case.
Yes, that's
or charge,
the
I should say.
Yeah, that's the stalking case. Judge, I don't know what else to say except as a first offender, having done almost a month, I know that the court has some concerns after we'll hear from probation or hearing from probation, that it appears superficially that this young man has not accepted responsibility. I can tell you, Judge, that just culturally for him, it's very difficult to go out into the community in front of his family and his parents and his friends and admit that he committed these crimes. I think it's frankly, Judge, hard for him to say it to himself, but he clearly has accepted responsibility. You're going to hear his acceptance of responsibility, which was not coached by either Mr. Deeb or myself. It's going to be a heartfelt, from his soul, Your Honor, apology. He dearly loves the victim in this case. He has not been able to have any relationship with his baby. And again, I'm not saying woe is me, Judge. These are all consequences of what happened that night, and he knows it. I'd ask Your Honor to consider a community control sanction. I think with proper rehabilitative services that your wonderful probation department can render for this young man, it's going to be much better than just housing him in a facility where any counseling or any help, and then he just comes out and he's in the same place he was before. He could certainly use anger management. He could certainly use some parenting classes. He has to learn how to deal with life stress in relationships and not allow things to get physical. No matter what, he can get physical. And I think he knows. So, Your Honor, I would submit most respectfully that a community control sanction would not demean the seriousness of the offense, and through adequate programming, it will ensure that this young man does not reoffend. And we're going to ask you, Judge, if you could exercise your discretion to grant him a community control sanction. You know, normally if it hadn't been defined as a crime of violence under 2929.01, he'd be an excellent candidate. I mean, it'd be almost a slam dunk, as they say. But these are crimes of violence, and he knows it. And certainly if you exercise your discretion to send him to prison, he's going to have to just go do his time. And he knows it. He's been thinking about that for the last, there's nothing else in his life. He's consumed with trying to make certain that you understand he gets it. And Judge, I think this is one man who, if you give him a break, he's not going to disappoint this court. Thank you.
Thank you. Mr. Deeb?
Your Honor. One other thing that we would like to address, Your Honor, is would like to be in his son's life, and also in Destiny's that she would have it so they can co-parent at the very least together. So we'd ask that the no contact be removed. I believe that both parties want that, but we're definitely asking on behalf of Mr. Albana that he be able to communicate and see.
Wasn't there a TPO?
It's a temporary protection order in addition to the no contact on the bond. But he would like those removed so that
Where was the
family from Willoughby Municipal Court
as at the time with the domestic violence?
at the time of the arraignment.
So it's not a separate.
It's in this case. No, it's
Oh,
not
it's in this
something
case.
to-
Gotcha. All right.
It's not
Gotcha.
something to the common police court. It just came with this case as
Gotcha.
from the Willoughby Municipal Court.
Judge, I believe it was a criminal protection order.
Right. I got it
And
now.
then
I mean,
when-
that goes away when the
that
case
goes
is
away
over.
when this
Right.
gets
I
finalized.
thought it was a separate order that
No.
was
I apologize,
obtained
Your Honor.
through filing of a motion for that.
Thank you, Your Honor.
You're welcome. Mr. Albana, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor. I'm not good with my work, Your Honor. I had a lot of sleepless nights here, Your Honor. I take full responsibilities and actions and realize how I hurt my love of my life. I love myself, my family, and my loved ones. I will comply with whatever sentences you tell me to, Your Honor. I just want to be a better me. I'll do whatever you tell me I have to do. Your Honor, I promise you, you'll never see me here again, Your Honor. I promise you that. I just want to see my son. I never seen my son yet. I'm going to meet him.
Please be quiet. Go ahead.
I'm sorry, Your Honor. I'm not good with my words. But if I
That
was
wasn't
good with my
directed. That wasn't directed to you. That was to the folks in the
If
back.
I was good with my words, you'll understand how sorry I am. I take full responsibility for everything. I'm ashamed of it. I'm embarrassed, Your Honor.
Thank you.
That's all, Your Honor.
Roxanne. I don't want to get up in front of everybody.
Thank you.
You need to be quiet in the back, please. Cuts for the state of Ohio.
Thank you, Your Honor. Your Honor, this is a case that is not a one-time incident. As this court is aware, the defendant pled guilty to menacing by stalking, which requires a pattern. As the count indicates, timeframes were honored between January 1st of 2024 and the 7th of 2025. In addition to the incident that occurred on January 7th that brought the police to the home that the defendant and Ms. Williams were sharing at that time, there were other incidents where the victim had taken pictures of injuries that she had sustained from the defendant, from black eyes to redness, from bruises and scratches. There are various pictures of those and incidents that had continued on. They had lived together at first at his family's home, and then they moved into a home on their own. On this incident, the night before the police were called, the defendant had thrown a phone at Ms. Williams and struck her in the head, cutting her head. And then in the morning later that day, there was another confrontation where he bit her, he slapped her, he pulled her hair, things of that nature. The police were called. There was somewhat of a confusion. It was an accidental calling, but the police arrived and spoke with Ms. Williams, who initially didn't indicate that anything had happened, but the police were aware that something had happened based on the visible injuries on her face. So they spoke with her. She did tell them what had been occurring. What makes this case more concerning or more serious than many is that at the time of the January incident, Ms. Williams was pregnant with the defendant's child. She was approximately 7-8 months pregnant while all of this was going on. So this incident occurred on January 7th. She went into the hospital on January 13th and had their son on January 15th. She was, my understanding, approximately 7 weeks early. So obviously that was a concern. As has been mentioned, the relationship did facilitate the offenses. And yes, that is part of what the domestic violence charge has, but menacing by stalking does not require that connection. So we do feel that is a factor that makes it more serious. And obviously they live together and they now have a child together. At that point, she was pregnant with their son. Defendant does not have an extensive criminal history, as has been alluded to in 2020, he had a possession of marijuana, drug paraphernalia, and possession of marijuana, and then in 2021, a possession of marijuana. That is concerning in the fact that the defendant, after he pled guilty, did test positive for marijuana on June 26th of 2025, so he did violate his bond, and his bond was revoked. Also, during the time frame, there's been a no contact and a temporary protection order in place. And during that time, though the state has not been told that there was direct contact, the defendant did post on Snapchat.
Yeah, I'm not considering this at all, this issue.
Okay.
If you felt that way, then you should have done something about that.
Obviously, the state is concerned about, in the pre-sentence report, there was some denying and minimization that occurred, as well as in the sentencing memorandum, indications regarding the victim initiating and things of that nature. We're obviously here today for the charges that the defendant pled guilty to, and those are concerning in and of themselves. So we do think, based on all the information, there's an argument that prison is consistent. However, we do understand that the defendant this is his first felony, and he did plead guilty at this stage. If the court does believe he is amenable, we would ask that he be ordered to complete the jail treatment program, decision point program, that he take anger management classes and complete those, that he have a mental health evaluation and follow any recommendations, that he does engage in parenting classes, that he obtain his GED, that he not use any drugs or alcohol, and that all periodic screens come back negative, that he have one doctor, one dentist, and one pharmacy, that he signed releases, that he engaged in full-time work. We are asking for no contact with Destiny Williams. She is going to address the court. She may have different views on that, but that is the state's position. And that the defendant, if he's given this opportunity, be made aware that if he does violate, that prison does then become a possibility for him again. And that would be the state's position at this time.
Thank you. This court has reviewed the...
Your Honor, I'm sorry. Ms. Williams does wish to speak.
Oh, okay. I'm sorry. Sorry? Okay. Where's that? Ms. Williams, you can just take your time, stand right there, state your full name, please, so it's clear who's speaking, and go ahead and say whatever you'd like me to know.
My name's Destiny Williams. I don't know. I wrote some stuff down because I didn't want to leave anything out that I had to say, if that's
You
okay.
can do whatever you want. You can read something. If you need your phone, you can use that if you have to. Take your time and say whatever you want me to know.
My name is Destiny Williams, and I'm here today as the mother of our 6-month-old son, Safe. This journey of being a first-time mom has been incredibly emotional, challenging, and life-changing. I never imagined of having to do it without his father being present. But that has been my reality from day one. This case started during a time when I was upset, angry, and overwhelmed. And while what happened between us can't be erased, I've had time to reflect as a mother, as a woman, and as someone who genuinely wants to build a better future, not stay stuck in the past. I want to be clear, I'm not here to excuse anyone's actions, but I'm also not standing here today to paint myself as a victim. I've done a lot of healing, and I've come to a place where I've chosen forgiveness. Not just for him, but for myself too. Carrying anger and resentment only wasted the future I'm trying to build for our son. The fact that he has already missed the birth of his first ever child. Not only that, but the first 6 months of his life, moments that can never be relived, is a consequence in itself. He has not even had the chance to meet our baby yet, and I do truly believe that's a powerful punishment in itself. One that has left an empty space in both of their lives. I know some people on my side might not understand or even support where I stand today. But I'm speaking today from a place of clarity and love and genuine desire to move forward in peace. Your Honor, with all of that being said, I do not want to see him go to jail. I ask, can we please work something out if possible, something that allows him to take responsibility but also leaves room for growth, for healing, and for the chance to be a father to Safe. I truly believe that would be taking a step forward, and it would be the best for everyone involved. Thank you.
Thank you.
And I also, I don't know if she told you or not, but the no contact order, I'm okay. Like, I want to have contact with him. I want to talk to him. I want to be able to talk to him about our son. I want him to meet him. I'm not saying get back together with him, but I just, that's everything that I had to say.
Thank you. This court has reviewed the pre-sentence report and investigation, the victim impact statement that I received. I received the sentencing memorandum, read and taken that into consideration. I've considered everything that's been said here today in open court by Mr. Schlackett, Mr. Deeb, the defendant himself, the relative that spoke on his behalf, cousin, probably, older cousin, prosecutor's comments, recommendations. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, court notes that in regards to the stalking charge, the relationship with the victim did facilitate the offense. Court also notes that the defendant was pregnant during the commission of at least part of the stalking, but the domestic violence for sure. So her condition, physical condition, exacerbated, injuries exacerbated due to the physical condition of the victim. No factors make it less serious. As for recidivism factors, the court notes there are the 2 prior convictions for the small misdemeanor charges involving marijuana. In regards to marijuana use, I'm not saying it's related to this offense at all, but there does appear to be an issue there, more so than the defendant acknowledges. He says it's not an issue for him at all, yet there's 2 convictions on your record related to marijuana use. A condition of your bond is that you don't use marijuana, and you went ahead and used it anyway. So that means one of 2 things. There's an issue there with it, and you couldn't help yourself with using it, or you don't care what the judge said or the court said in regards to no use of it. You went ahead and used it anyway. Those are the only 2 options there are. But it was a condition of your bond and your liberty was at stake, and you went ahead and used it, knowing that if you did, your bond could be revoked. You also claim they have the medical marijuana card. You've never used it. You've never used it to get any marijuana. So that's irrelevant. In regards to remorse, I'm not going to say there's not genuine remorse, but he certainly wasn't forthcoming with the probation department when he spoke with him. And you talk about how you're not good with words. Well, your words, they weren't confusing at all because they were the exact opposite of what you're saying now. You said, I did not put my hands on his girlfriend. You pled because you didn't want to take it to trial and make it worse. You tried to leave and she was attacking you. Those were your words. That's like 180 degrees opposite from what you're claiming that you did. You didn't take responsibility with the probation department. You then come in and say, I want to take full responsibility, but then you say what I just said. Whose phone is that? The phone should be turned off. She would not open the bedroom door, and when she did, her hand flew back and her hand was close to his mouth and she ran into your mouth. That's how apparently she got bit, because she ran into your mouth. You didn't say you did anything to her here. That's not accepting responsibility. And this isn't a one-time incident. The felony charge of menacing by stalking you pled to involves conduct that occurred over a year's period of time. As for factors indicating recidivism is less likely, the court does note that aside from the 2 minor misdemeanor, I don't know if they were minor misdemeanors, but they weren't minor misdemeanors, they were low-level misdemeanors, marijuana charges, there's nothing else on his history. And that's a factor indicating recidivism is less likely. Under 29-29-13b1, the defendant did cause physical harm to a person. That overrides any presumption for probation and permits the court to impose a prison sentence without having to make any findings in that regard, or any findings to overcome a presumption. Prison, however, at this point, based on the defendant's history, is not consistent with the purposes and principles of sentencing, and I will give you a chance, despite what I find to be your lack of accepting responsibility here. find you're amenable to an available community control sanction. But if that's how you truly believe, and you don't think you did anything wrong here, you're going to have a difficult time succeeding on probation, because you're going to be required to do certain things, and you're going to be feeling like I shouldn't have to be doing these things because I didn't do anything wrong. And if that happens, we're going to be back here. I hope that's not the case. I'm not saying it's going to be the case, but typically when someone doesn't think they did anything wrong and they're required to do things that they don't really want to do, that's what happens. I'm going to put you on community control sanctions for a period of 2 years. There's going to be consequences, though. You assaulted an 8-month pregnant woman. I'm not just going to ignore that. And that's not even talking about whatever happened, the stalking stuff that happened for a year. Putting you on community control sanctions for a period of 2 years. You're going to be ordered to serve 90 days in the jail. You have credit for 29 days you've already served. You're going to enter and successfully complete the jail treatment program, as well as the decision points program. Upon conclusion of that, you are to have no use of any drugs or alcohol, and that includes no marijuana use. You're to submit random urine screens. They must be negative. I want you to follow whatever aftercare recommendations are from JDP. I'm not going to order any specific AA meetings. If they say you need to do some, those will be conditions of your probation. If they say it's not necessary, then I won't make you do them. Whatever recommendations come from JTP will be, in regards to AA meetings, will be a condition of your bond. You're to obtain and maintain full-time employment. You mentioned wanting to get your GED. Is that something you really want to do?
I would definitely do it, yes,
Well, then
Your
I'm
Honor.
going to order that you at least make a reasonable effort at obtaining your GED. To obtain anger management counseling. Pay court costs and supervision fees. Where's the probation officer? Oh, Derek. Sorry. Derek, is there anything else I'm missing here I should be considering?
Your Honor, the only thing up in there would be the no contact.
Well, I'm not ordering that at this point. Victim came in here and says she doesn't want that. I'm not ordering it. Mr. Albani, understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
You'll never ever see me here again, I promise you, Your Honor.
All right, I want to know if you have any questions for me.
No, Your Honor.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 18 months on count 3, an additional 12 months on count 4 to be served consecutive to each other for a total of 30 months in prison. You understand that?
Yes,
And that
Your
would be
Honor.
consecutive to any other sentence that you may be serving at that time for something else, or that you're being sentenced to. I will further dismiss the rest of the charges in the indictment, and I'm going to order the release of defendant's bond. It's not being forfeited, so your bond will be released.
Thank you, Your Honor.
I'll be released.
Your bond is released.
Mr. Schlacker, Mr. Deeb, anything else?
I'm going to say thank you, nothing further, Your Honor.
Ms. Cutts.
Your Honor, I just want to clarify 2 things. Is the community control sanctions concurrent on each count?
Yes, yes.
And you had mentioned, you had said anger management counseling. I didn't know if you meant anger management and counseling.
No,
or that
anger
was
management.
counseling. Okay,
Just anger management.
thank you.
I mean, they'll address whatever